Hello, everyone. Welcome to Internet Law Review. For today's story, we have a decision from the United States Supreme Court. This is a unanimous decision. Weyerhaeuser v. United States Fish and Wildlife Service. Let's see what they have to teach us. The Fish and Wildlife Service administers the Endangered Species Act of 1973 on behalf of the Secretary of the Interior. In 2001, the service listed the dusky gopher frog as an endangered species. That required the service to designate critical habitat for the frog. The service proposed designating, as part of that critical habitat, a site in St. Tammany Parish, Louisiana, which the service dubbed Unit 1. A parish is exactly the same as a county. In most states, they just called it a different name in Louisiana. That frog had once lived in Unit 1, but the land had long been used as a commercial timber plantation, and no frogs had been spotted there for decades. The service concluded that Unit 1 met the statutory definition of unoccupied critical habitat because it is rare, high-quality breeding ponds, and distance from existing frog populations made it essential for the species conservation. The service then commissioned a report on probable economic impact of its proposed critical habitat designation. With regard to Unit 1, the report found that the designation might bar future development of the site, depriving the owners of up to $33.9 million. The service nonetheless concluded that the potential costs were not disproportionate to the conservation benefit and proceeded to designate Unit 1 as critical habitat for the dusky gopher frog. Unit 1 is owned by petitioner Weyerhaeuser and a group of family landowners. The owners of Unit 1 sued, contending that the closed canopy timber plantation on Unit 1 could not be critical habitat for the dusky gopher frog, which lives in open canopy forests. The district court upheld the designation. The landowners also challenged the service's decision not to exclude Unit 1 from the frog's critical habitat, arguing that the service had failed to adequately weigh the benefits of designating Unit 1 against the economic impact, had used an unreasonable methodology for estimating the economic impact, and had failed to consider several categories of costs. The district court approved the service's methodology and declined to consider the challenge to the service's decision not to exclude Unit 1. The Fifth Circuit affirmed, rejecting the suggestion that critical habitat definition contains any habitability requirement, and concluding that the service decision not to exclude Unit 1 was committed to agency discretion by law and was therefore unreviewable. So what we see here is a clear conflict between the United States government, through the Endangered Species Act, and the rights of private homeowners and private landowners. This particular land was forested, but was the wrong kind of forest for the frog in question that the Wildlife Service was designating as protected by this particular land. The Wildlife Service argued that the land could be made habitable by changing the kind of forest, which presumably would require removing the forest that was currently there and replacing it with a different forest. The landowners contended, by contrast, that in order for it to be critical habitat, it must first be habitat. And because the frog in question did not, and in fact could not live in the land in question, it could not be critical habitat within the meaning of the law. Both the District Court and the Court of Appeals agreed with the United States Fish and Wildlife Service that this land could be considered critical habitat, even though the frog did not and could not live in the land as it was currently comprised. So the United States Supreme Court is taking review to see whether or not the District Court and the Fifth Circuit was correct, that the United States Fish and Wildlife Service should win, or rather, in contrast, the private landowner should win. So let's see what they decided. Held. An area is eligible for designation as critical habitat only if it is habitat for the species. That provision, the sole service of authority for critical habitat designation, states when the Secretary lists a species as endangered, he must also, quote, designate any habitat of such species which is then considered to be critical habitat, unquote. It does not authorize the Secretary to designate areas as critical habitat unless it is also habitat for the species. The definition allows the Secretary to identify a subset of habitat that is critical, but it leaves the larger category of habitat undefined. The service does not now dispute that critical habitat must be habitat, but argues that the habitat can include areas that, like Unit 1, would require some degree of modification to support a sustainable population of a given species. Weyerhaeuser argues that the habitat cannot include areas where the species could not currently survive. The service in turn disputes the premise that the administrative record shows the frog could not survive in Unit 1. The Court of Appeals, which had no occasion to interpret the term habitat or to assess the Services Administration's finding regarding Unit 1, should address those questions in the first instance. So far we see the United States Supreme Court has said clearly that in order for it to be critical habitat, it must first be habitat. However, while critical habitat is defined as including habitat, the Supreme Court notes the statute does not actually define what habitat is. But the Supreme Court notes that the frog does not currently live in this place. Because the Court of Appeals did not designate what a habitat is, the Supreme Court is sending this back to the Court of Appeals so that they have to define habitat in the first instance. However, the decision from the United States Supreme Court makes very clear the United States Supreme Court believes that this is not habitat, so that while the United States Court of Appeals is somewhat free to designate what a habitat is, the Supreme Court has made very clear their preference, and so we can expect the Court of Appeals to follow. Continuing on, the Supreme Court notes that the Secretary's decision not to exclude an area from critical habitat is subject to judicial review. The Administrative Procedure Act creates a basic presumption of judicial review of agency action. The service contends that the presumption is rebutted here because this action is committed to agency discretion by law because the statute is one of those rare provisions drawn so a court would have no meaningful standard against which to judge the agency's exercise of discretion. The Supreme Court states that the law describes a unified process for weighing the impact of designating an area as critical habitat. The provision's sentence requires that the Secretary take into consideration economic and other impacts before designation, and that the second sentence authorizes the Secretary to act on his consideration by providing that he may exclude any area from critical habitat if he determines that the benefits of such exclusion outweigh the benefits of the designation. The word may certainly confers discretion on the Secretary, but it does not segregate his discretionary decision not to exclude from mandated procedure to consider the economic and other impacts of designation when making his exclusion decisions. The statute is, therefore, not, quote, drawn so that a court would have no meaningful standard against which to judge the Secretary's exercise of his discretion, unquote, not to exclude. Weyerhaeuser's claim that the agency did not appropriately consider all the relevant statutory factors meant to guide the agency in its exercise of its discretion is the sort of claim that the federal courts routinely assess when determining whether to set aside the agency decision as an abuse of discretion. The Court of Appeals should consider, in the first instance, the question of whether the service's assessment of the costs and benefits of designation and resulting decision not to exclude Unit 1 was arbitrary, capricious, or an abuse of discretion. And here noting that Chief Justice Roberts wrote the decision of the court in which all other members joined, except for Kavanaugh, who did not take place in this decision because he was not a member of the court when this decision was initially argued. So that is the decision of Weyerhaeuser v. United States Fish and Wildlife Service. The bottom line is that the United States government, when interpreting the Endangered Species Act, may designate habitat as critical habitat only upon a couple of conditions. First, it must currently be a habitat for the species in question, and secondly, they must consider a number of designated factors in the statute to consider where the designation of it as a protected habitat is overall in the public interest or not. Here, the United States Supreme Court notes that both the Court of Appeals and the District Court failed on both instances and has sent it back to the Court of Appeals for decision on both of these factors. The Court of Appeals has been all but told that they must determine that this is not critical habitat, but the Supreme Court is making them do it rather than them do it because the Supreme Court is basically signaling that you got it totally wrong and therefore you do our homework because you should get this right. So it is a bit of a reprimand to the court below, but that is how it goes sometimes. So that is the decision of Weyerhaeuser v. United States Fish and Wildlife Service, interpreting the Endangered Species Act. I hope this has been helpful and educational. Until later, my friends, this has been Internet Law Review. I hope all is well, and cheers. Bye.